Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey.
Yeah, we have a really wild one today.
We do. And, before we even get into the documents, I want the listener to just imagine something for a second. Imagine you're hundreds of feet underground.
Right.
The air is just, incredibly thick with coal dust.
It's pitch black, mostly.
Exactly. And the noise of all this heavy machinery is totally deafening. You're inspecting a piece of industrial equipment, and suddenly, the geological pressure just becomes too much.
The literal walls cave in.
Yeah, the wall of coal right next to you just gives way. The roof caves in, and you're completely buried under thousands of pounds of rock and coal.
It's basically a nightmare scenario.
It is. And by the time your coworkers desperately dig you out, you're screaming in agony, your leg is shattered in 4 different places.
It's a horrific physical injury.
But here's where it gets crazy. As you're lying there bleeding in the rubble, your boss doesn't call an ambulance.
No, he doesn't.
Instead, he looks at the crew that just saved your life and says, if anyone breathes a word about this accident to anyone, you are all fired.
Which is just, it's stunning.
Right. And then he throws you in a vehicle and secretly smuggles you off the property.
It sounds like, the opening scene of a thriller movie or like some nightmare from the unregulated Industrial Revolution.
Totally.
But this is a completely real, highly documented event that actually occurred in September of 2019.
Yeah.
And what unfolds from that exact moment is this labyrinthine corporate cover-up. It involves looming FBI investigations, secret trips to the hospital.
Cocaine distribution somehow.
Yes. A corporate executive gets arrested for cocaine distribution later on, and it all leads to this high-stakes legal battle that really challenges our fundamental understanding of workplace rights.
Which brings us to the actual mission of our conversation today. Mark has selected this incredibly wild case in order to highlight the different employment law in the state of Montana under the Wrongful Discharge from Employment Act.
Right, the WDEA.
Right, which is the only state in the country that uses a for-cause termination statute instead of an at-will rule.
It's totally unique.
It really is. So, Mark is highlighting Montana cases to give listeners a new perspective in comparison to the at-will rule followed in every other state in the country.
And to really map out this alternate legal reality, we're looking at some incredible source materials today.
Oh, yeah, the documents are fascinating.
We have a civil complaint that was originally filed by the injured minor, a man named Justin Cowger. And we also have a 2023 U.S. District Court order regarding a motion for summary judgment in the resulting case, which is Cowger v. Signal Peak Energy.
Right. And I think we need to establish right up front why you listening in traffic or at your desk, need to care about a coal mine in Roundup, Montana.
Exactly.
Because even if you have never worn a hard hat in your life, understanding the stark difference between at-will employment and for-cause employment completely reframes how you view your own rights.
It completely changes the balance of power in the workplace.
Yeah, so let's pull that apart first. What does at-will employment actually look like for, say, a normal office worker on a random Tuesday?
Well, it's the baseline reality for 99% of American workers. In 49 out of 50 states, you are at a will.
And people hear that and usually think it just means, I can quit my job whenever I want.
Right, which is true. But it is vastly more weighted in the employer's favor. It's totally asymmetrical.
How so?
Being an at-will employee means your employer has total, absolute discretion over your livelihood. They can walk into your office today and fire you for literally any reason under the sun.
Or no reason at all, right?
Exactly. They can wake up in a bad mood, decide they don't like the color of your shirt, and just terminate your employment.
Wow.
They can fire you for a totally terrible, unfair, factually incorrect reason.
So there's almost no protection.
The only limitation, the only shield you actually have in those 49 states is that they cannot fire you for an explicitly, legally discriminatory reason.
Like race, gender, religion, things like that.
Right. Barring blatant discrimination, you basically have zero job security.
It always makes me think of, bad relationships.
Oh, that's a good comparison.
Because being an at-will employee in 49 states is mechanically identical to being dumped via a vague text message.
Yes, exactly.
It's like, hey, it's not you, it's me. We're done. Or, I just don't feel like dating anymore. You have no recourse. You can't demand a trial to prove you were a good partner. You just have to pack your bags and leave.
That captures the arbitrary nature of it perfectly. But then you cross the state line into Montana.
And everything changes.
Everything changes. You encounter the Wrongful Discharge from Employment Act. Back in 1987, Montana fundamentally flipped the script on the American workplace.
Okay, so how does it work?
Under the WDEA, which is the exclusive legal remedy for a wrongful discharge in that state, a boss's ability to fire you is no longer arbitrary. A discharge is legally classified as wrongful if it violates one of three core pillars.
Let's examine these pillars because I think this is where that balance of power really shifts. What's the first pillar protecting a worker in Montana?
So the first pillar is public policy. A discharge is wrongful if it's in retaliation for the employee refusing to violate public policy or for reporting a violation.
Okay, so that's basically classic whistleblower protection.
Exactly. If your boss asks you to, dump toxic waste into a river and you say no, they cannot legally fire you for that refusal.
Which makes total logical sense.
Sure.
And frankly, it feels like something that should just be universal everywhere.
You'd think so. But it's the second pillar that really blows up the traditional American employment model.
Right. Let's dig into that one.
The second pillar is the most consequential. It says a discharge is wrongful if it is not for good cause after the employee has completed their probationary period.
Okay, we need to define good cause in a courtroom context here.
Yeah.
Because the word good is incredibly subjective.
Very subjective.
Right. Like what I think is a good cause to fire someone might be totally different from what my CEO thinks is a good cause.
Well, the statute doesn't leave it up to feelings, thankfully. It defines good cause legally as reasonable job-related grounds for dismissal.
So they need actual proof.
Right. It requires a tangible business justification. So this could be a documented failure to perform your job duties.
Okay.
Or it could be actively disrupting the employer's operations or a material violation of written policies. And then there's a catch-all provision for other legitimate business reasons.
So if we go back to my breakup analogy.
Yeah, let's hear it.
Montana's law is basically like passing a law requiring your partner to sit you down and present a notarized, legally binding list of reasonable, documented grievances.
That's a great way to look at it.
Like they have to say, you never wash the dishes, or you keep crashing my car. And they have to prove the relationship is failing based on actual, measurable data before they can legally break up with you.
Yes. And here is the kicker. If you dispute their data, you can take them to court.
Wow.
You can have a jury decide if their grievances were real or just completely fabricated. That is the true power of the WDEA.
And just for the sake of completion, what was the third pillar?
The third pillar is if the employer violates the express provisions of its own written personnel policy during the firing process. So if your employee handbook says you get 3 written warnings before termination and they fire you on the first strike.
Then that's a wrongful discharge.
Exactly.
Okay, so we have this incredibly unique, highly protective legal ecosystem in Montana. If you pass probation, you have actual substantive job security.
Which brings us back to Justin Cowger.
Right. To understand how this protective shield collides with a massive corporate crisis, we have to travel back underground to the Signal Peak Energy coal mine. This is September 16th, 2019.
Let's set the scene here. Cowger is a longwall coordinator at the mine. He's not a new guy.
No, he's a veteran.
Yeah, he's been with the company since 2010. He worked his way up the ranks. He received great performance reviews, and he completed his probationary period nearly a decade ago.
So he is firmly protected by that good cause standard we just talked about.
Absolutely.
Now, for anyone listening who isn't familiar with the mechanics of the industry, longwall mining is arguably one of the most intense, dangerous industrial processes on Earth.
It really is.
They use this massive, heavily mechanized equipment to just shear off a colossal wall of coal in a single continuous slice.
It involves immense geological pressure.
Right, and deafening noise, constant hazard. So on this particular Monday, Cowger is positioned under a protective hydraulic shield. He's trying to inspect a damaged piece of equipment called a pan line, or a shear.
And this is where the environment just turns lethal.
Yeah.
Without any warning, the coal gives way. The wall and a portion of the actual mine roof simply collapse inward.
Just collapses right on him.
Completely buries him under an avalanche of coal and rock.
The visceral terror of that moment is, it's hard to overstate. He is trapped in the dark, actively being crushed.
And he is eventually extricated by his crew, but the physical damage is catastrophic. Like you said, his leg is shattered, broken in 4 different places.
Now, in any normal workplace, The next sequence of events is pretty automatic. You call 911, you halt operations, secure the area.
Right, you notify federal safety regulators immediately.
Exactly. But the immediate, almost instinctual reaction of the mine's management is what elevates this from a tragic accident into a full-blown legal thriller.
Because according to the complaint, while Cowger is bleeding and basically immobilized, a man named Dave Brown steps in.
And Brown is the long wall planner, right?
Yes. But he doesn't bring a first aid kit. He brings threats.
This part is so wild to me. Brown turns to the hourly workers, the guys who literally just pulled Cowger out of the rubble, and he zeroes in on one specific miner, a guy named Travis Gulick. And Brown explicitly tells the crew that if they breathe a single word about this cave-in to anyone, they will all lose their jobs.
It is a stunning display of misplaced priorities. I mean, a man's leg is shattered, he is in agonizing physical pain, and management's immediate reflex is to issue a gag order.
Yeah.
And Brown's actions escalate from verbal threats to active concealment.
What does he do?
He actually places the severely injured Cowger into a vehicle and drives him out of the mine in secret.
Oh, wow.
Yeah, ensuring that nobody else on the property sees the physical state he's in.
It's totally clandestine. But, you know, Cowger isn't an idiot. He knows his leg is destroyed. He knows he needs a hospital immediately.
Right.
But before he even gets to an emergency room, he makes a fateful phone call to his supervisor, Dale Musgrave.
And Musgrave is a heavy hitter. He's the vice president of underground operations for Signal Peak.
Right, so you'd expect the VP to express concern, or at least, I don't know, launch basic safety protocols.
Instead, Musgrave's reaction is deeply troubling. It's incredibly revealing about the corporate culture at Signal Peak.
What does he say?
Musgrave tells Cowger over the phone that this is, and I'm quoting directly from the complaint here, a bad time for this to be happening.
I just need to pause on the sheer narcissism of that statement.
It's unbelievable.
It's like, hey, Justin, I know your femur is currently in multiple pieces, but your shattered bones are just really inconvenient for my schedule right now.
Right. But we have to look at the underlying mechanics here. Why was it a bad time? Like, what was causing this extreme level of corporate paranoia?
Because context is everything. At the exact moment Cowger is bleeding in that vehicle, Signal Peak Energy is already under intense scrutiny.
Okay, from who?
They are currently facing active investigations by both the FBI and the Environmental Protection Agency for other completely unrelated issues at the mine.
Okay, so the executives are already looking over their shoulders. Federal agents are literally already sniffing around the property.
Precisely. And in a highly regulated industry like mining, a catastrophic workplace injury triggers an automatic invasive investigation by the Mine Safety and Health Administration.
Right, MSHA.
Yeah, MSHA. The last thing Vice President Musgrave wants is another federal agency swooping in, halting operations, auditing their safety records, and potentially uncovering whatever else the FBI and EPA are already looking for.
The motivation for the cover-up clicks perfectly into place. It's just self-preservation at the highest level. So Musgrave takes a drastic step. While Cowger is en route to medical care, Musgrave explicitly threatens him with termination.
Over the phone, while he's in the car.
Yes. He tells Cowger that if he does not agree to report the cave-in as a personal injury that happened at his home, he will be fired.
That is literal extortion.
Musgrave tells him he needs to protect the company, and he promises that if Cowger plays ball and lies to the doctors, he will be taken care of like the other guys.
Okay, taken care of like the other guys. That phrasing is chilling.
Very.
Because the complaint specifically alleges that Signal Peak had an established pattern and practice of hiding legitimate workers' comp injuries from regulators.
This wasn't a one-off panic attack.
No, it was standard operating procedure.
And you just have to put yourself in Cowger's shoes in that vehicle. This is the crux of the psychological pressure. He's experiencing profound physical trauma. He's facing major surgery, a long, painful rehab.
Yeah.
And at the most vulnerable moment of his life, the vice president of his company is holding his entire livelihood hostage over the phone.
His ability to feed his family is on the line.
Exactly. Musgrave is demanding he commit a massive ethical and legal breach, lying to medical professionals and the federal government as the explicit price of keeping his job.
The power dynamic is completely overwhelming.
Yeah.
So Cowger, terrified of losing his income while facing these massive medical bills, he just complies with the extortion.
He does.
He gets to the hospital and he lies to the triage nurses and the doctors. He claims he injured himself riding an ATV at his house.
And the physical reality of the injury makes the lie even more desperate. I mean, the damage is so severe he requires immediate invasive surgery.
Right.
On September 19th, orthopedic surgeons insert a massive metal plate and 7 metal pins into his leg just to hold the bones together.
Oh, my God.
And because of the sheer physical trauma of the cave-in and the surgery, Cowger completely misses work on September 16th, 17, 18, 19, and 20.
So that's 5 full days of missed work due to major surgery from a workplace accident, and it's all being actively swept under the rug.
Which moves us directly into the administrative phase of the cover-up.
Right, because a lie this big has a terrifyingly short shelf life.
It really does.
When you're dealing with a rigidly regulated industry, hundreds of employees, and an injury that requires hardware to be drilled into a man's skeleton secrets, just do not stay buried. A paper trail is inevitable.
And that is the fatal flaw in Musgrave's plan. Cover-ups require absolute institutional silence and perfect administrative control.
Which they didn't have.
Not at all. On September 23rd, just days after getting a metal plate screwed into his leg, Cowger somehow manages to return to work, and he discovers that the house of cards is already collapsing.
How does that unravel so fast?
An anonymous tip.
Oh, wow.
Yeah, MSHA, the Federal Safety Agency, receives a call from someone detailing the severity of Cowger's injury.
Someone on the crew must have talked.
Probably. So Curtis Floyd, who is the director of safety for Signal Peak, approaches Cowger. He says MSHA is sniffing around, asking pointed questions about Cowger's exact location and activities on the day he was supposedly injured on an ATV.
So they know the ATV story is fake.
Yeah. Floyd tells Cowger the gig is up, the lie isn't holding, and they have to formally report the incident to MSHA before the federal inspectors show up with subpoenas.
Okay, so the safety director knows, and he knows they are trapped. Cowger, panicking, immediately goes to his boss, Vice President Musgrave.
Right, the exact man who forced him to lie under threat of termination in the first place.
Right. He goes to him and tells him what Floyd said. The feds know, we have to report it. And Musgrave's reaction here is an absolute masterclass in cowardly corporate backpedaling.
It's unbelievable. Musgrave immediately attempts to sever his own connection to the conspiracy. He tells Cowger to his face that he could not be a part of this.
Let's just test the logic of what Musgrave does next, because it is absurd.
Yeah.
He tells Cowger to go to the interim CEO of the company, a man named Joe Farinelli, and confess.
Yes.
But the instructions for the confession are incredibly specific. Musgrave instructs Cowger to tell the CEO that the cave-in did happen at the mine, but that Cowger himself had initially chosen to falsely report it.
It's the ultimate betrayal.
Yeah.
The executive who orchestrated the crime is ordering his subordinate to take 100% of the blame.
Just throwing him under the bus.
Completely. He tells him to paint himself as a lone rogue employee and to leave executive management's name entirely out of the narrative.
And what happens when Cowger actually limps into the CEO's office and delivers this highly sanitized, heavily edited confession?
According to Cowger, Farinelli accepts the story without a single follow-up question.
Are you serious?
Dead serious. He doesn't ask how the accident happened. He doesn't ask who was present. He doesn't ask why a loyal 10-year veteran employee would randomly decide to lie about a catastrophic workplace injury and claim it was an ATV accident.
The lack of curiosity is the tell.
Definitely.
It heavily implies that the CEO already knew the exact contours of the cover-up. It's a strategy of willful blindness. Like, don't ask questions that generate liability. Just let the subordinate take the fall so the paperwork looks clean.
And speaking of paperwork, even when they are forced to finally file the official injury report with MSHA, they still cannot bring themselves to tell the complete truth.
What did they do to the form?
On the official federal form, the 5 days Cowger spent in a hospital bed recovering from major reconstructive surgery are bizarrely and falsely categorized as vacation time.
Wait, they coded his surgical recovery as a paid vacation?
Yes. And Cowger was obviously not scheduled to be on vacation.
Right.
Now, Cowger later claims in his lawsuit that he had zero involvement in how those specific days were categorized by human resources on that federal form.
Okay.
However, he does admit a crucial damaging fact. When he subsequently sat down for formal interviews with MSHA investigators, he actively downplayed the severity of his injuries, still trying to follow Musgrave's initial directive to protect the company.
He is in so deep at this point.
He really is.
He's trying to patch a collapsing dam from the inside. But as we move into the winter of 2019, the entire power structure of Signal Peak Energy goes into free fall.
Right.
Because a cover-up relies on the people in charge staying in charge.
Exactly. And this is where those background FBI and EPA investigations suddenly come crashing into the foreground. In December 2019, Vice President Dale Musgrave, the architect of this coercion, is fired.
Wow.
But he is not fired because the company suddenly discovered his unethical handling of the mine collapse. He is fired because he is arrested and federally charged with the possession and distribution of cocaine.
I cannot get over how wild this workplace is. The vice president of underground operations goes down for trafficking cocaine.
It's wild.
That completely obliterates the existing power dynamics at the mine.
It creates a massive vacuum, and it brings in a totally new regime. By February 2020, Signal Peak hires a new VP of underground operations, Parker Phipps.
Okay, Phipps.
And Phipps inherits a company that is essentially a radioactive liability. They are in the crosshairs of multiple federal regulators. Their previous VP is facing serious drug charges, and Phipps starts hearing persistent rumors about the timeline of Cowger's accident.
So Phipps starts pulling on the threads. Because logically, he looks at the MSHA report and says, how does a man get crushed by a coal wall, require a metal plate in his leg, and theoretically not miss a single day of work because he was conveniently on vacation?
The math doesn't add up. So the new VP launches an inquiry. Now, Cowger asserts this wasn't even a rigorous formal investigation. He claims Phipps simply asked the HR director and Curtis Floyd.
Wait, the same Curtis Floyd who was the safety director?
Yes, the very same safety director who helped misreport the injury to MSHA in the first place. Phipps asked him to gather information and summarize what happened.
Regardless of the methodology, the political reality is clear. The new regime is ousting the old regime.
Yes. On March 25, 2020, Curtis Floyd quietly amends the official MSHA report to accurately reflect that Cowger missed 4 days of work due to the injury.
Okay, so the truth is finally on paper.
Right. And then the dominoes fall fast. 2 days later, on March 27, Signal Peak terminates Justin Cowger. They escort him off the premises, and they don't even allow him to return to his office to retrieve his personal effects.
Just boom, gone.
And Cowger wasn't the sole casualty. The new management initiates a purge. They also fire Dave Brown, the planner who initially threatened the crew and smuggled Cowger out of the mine, citing his role in the cover-up.
Makes sense.
And they fire Curtis Floyd, the safety director. Though, in a bizarre twist of corporate logic, they don't cite his role in the Cowger cover-up. They cite his failure to report a completely different workplace injury as the official reason for his termination.
You know, think about this from the perspective of an employee in a transitioning company. If a new executive team comes into your office tomorrow, especially a company under FBI investigation, their primary objective is risk management.
Oh, 100%.
They want to eliminate liabilities, clean the books, and aggressively distance themselves from the corrupt practices of the old guard. They want to be able to point to a pile of fired employees and tell the regulators, look, we cleaned house.
It's a textbook corporate sanitization strategy, but look at the devastating position it leaves Justin Cowger in.
Right.
He followed direct orders from his vice president to protect his job, and now he's being fired by the new vice president for following those exact orders.
This is so twisted.
And furthermore, because he initially yielded to the extortion and told the hospital it was an ATV accident, his legitimate workers' compensation claim was completely denied.
Oh, man, I didn't even think about that.
He is sitting at home, unemployed, with a leg full of metal, while collection agencies hound him for massive, unpaid surgical bills.
If he lived in any of the other 49 states, his story would end right here in bankruptcy.
Literally.
But, crucially, Justin Cowger lives in Montana. He has the Wrongful Discharge from Employment Act, and he uses it to fight back.
Yes, he does. In March 2021, Cowger files a wrongful discharge complaint in Musselshell County. He comes out swinging.
What is he asking for?
He demands 4 years of actual wage loss, plus punitive damages, explicitly alleging that the company acted with actual malice and fraud. He even offers to arbitrate the claim.
Why offer arbitration? Usually, companies love arbitration because it hides things and employees want public juries.
Because under Montana law, offering arbitration is a highly strategic move. If the company accepts, the arbitrator is legally bound to apply the substantive protections of the WDEA. It streamlines the process while retaining the good cause standard.
That's really smart. So the case eventually gets removed to federal court, specifically the U.S. District Court in Billings.
Right.
And this is where we reach the most critical educational phase of this entire analysis. The motion for summary judgment. How does a judge actually filter a complex WDEA claim before a trial?
Let's break down the mechanics of summary judgment under Rule 56 of the Federal Rules of Civil Procedure. Signal Peak filed this motion, which is essentially a formal request asking the judge to look at all the undisputed facts, read the depositions, and declare that, as a matter of law, the company had an absolute right to fire Cowger.
Meaning a jury trial is completely unnecessary.
Exactly.
I always explain summary judgment using the analogy of a heavily guarded nightclub.
Okay, I like this.
The judge, in this phase, is the bouncer standing at the velvet rope. The bouncer's job is not to go inside the club, watch the dance battle on the floor, and decide who has the best moves.
Right.
That is the trial. That is the jury's job. The bouncer is just standing outside checking IDs. The only question the bouncer asks is, do you have a legally valid ID to get inside?
Yes.
And in legal terms, that ID is called a genuine dispute of material fact. If you have one, you get in. If you don't, your case is dismissed on the sidewalk.
That is an excellent framework. So Judge Susan P. Waters looks at Cowger's ID, his 3 claims under the WDEA. Remember those 3 pillars we discussed earlier?
Right. Retaliation for public policy, violating written policies, and firing without good cause.
Exactly. And the judge looks at the first 2 claims and determines the ID is fake.
Oh, wow.
Yeah, she grants summary judgment for Signal Peak on the retaliation claim and the violation of personnel policy claim.
Why did those fail?
Because the evidence didn't support the specific legal definitions. Cowger wasn't whistleblowing, he was actively participating in the cover-up for months, so the public policy retaliation claim fails.
Right, that makes sense.
And he couldn't point to a specific written HR policy that the company violated during the exact moment of his firing.
So 2 claims are tossed onto the sidewalk.
Right.
But the third claim, the second pillar of the WDEA, is where the bouncer unhooks the velvet rope.
Yes.
The judge ruled that the core good cause claim survives. A jury must hear it.
And the mechanical reason that claim survives is fascinating. Because in order for a jury to determine if a company had a good reason to fire someone, the court first has to definitively establish what the actual reason was.
Right. You can't judge the validity of the cause until you agree on the cause itself.
Exactly. And in this case, Signal Peak and Cowger are telling 2 completely different, fundamentally incompatible stories about why he was walked off the property.
This brings us to the he said, corporation said section of the dispute. Cowger claims that when he was escorted out of the building, he was verbally told he was being fired for his initial failure to report the cave-in on September 16th.
Which is the lie he explicitly argues he was extorted into telling by Vice President Musgrave.
Right. But Signal Peak's corporate lawyers insist in their legal filings that they absolutely did not fire him for that initial lie.
No, they claim they fired him for his later administrative conduct.
What conduct?
Specifically, his complicity in allowing his days off to be misreported as vacation days on the official federal MSHA form over a week later.
Now, a reasonable person might listen to this and think, who cares? Cave-in lie, vacation lie, it's all part of the same messy cover-up.
Right.
But under Montana employment law, this semantic distinction is everything. And it relies on something called the Galbreth rule. Walk us through how this rule changes the game.
The Galbreth rule is a vital substantive piece of employment law in Montana. It was established by the state Supreme Court in a case called Galbreth v. Golden Sunlight Mines.
Okay.
The rule states that if a discharged employee demands a written termination notice explaining exactly why they were fired, the employer is legally obligated to provide it.
Okay, that seems fair.
And here is the teeth of the rule. If the dispute eventually goes to a jury trial, the employer is legally bound only to the specific reasons they listed in that initial letter.
And that is an incredibly powerful anti-gaslighting mechanism.
It really is.
Because in a normal state, a company can fire you vaguely, and when you sue them a year later, their high-priced lawyers suddenly show up to court with a newly invented list of 15 minor mistakes you made over the last decade to justify the firing retroactively.
Yes, happens all the time.
The Galbreth rule forces the company to lock in their story on day one.
It prevents moving the goalpost during litigation. But here is the massive wrinkle in Cowger's specific case. Signal Peak never gave him a formal termination letter, locking in their reason.
They just skipped the paperwork entirely.
They skipped it. But Cowger's lawyers went digging during the discovery phase anyway, didn't they?
They did. And during discovery, they unearthed an internal hidden document. It was an employee exit HR checklist.
Oh, wow.
Yeah. It wasn't given to Cowger, but it was filled out by Human Resources. On this internal document, HR officially stated that Cowger was discharged for violating company rules regarding reporting of accident.
Which perfectly supports Cowger's story.
Exactly. The internal document says the firing was about the accident reporting, not the later vacation days reporting on a federal form. The company's own internal paperwork contradicts their current litigation strategy in federal court.
It creates a massive factual collision. Signal Peak's lawyers tried to maneuver around this in front of the judge. They argued that they never actually changed their reason. They were just supplementing it.
Supplementing, yeah.
Yeah, they essentially argued, look, the vacation day lie on the MSHA form is just a natural extension of the initial accident lie. It's all one event.
Wait, hold on. I want to test this logic because, frankly, I kind of see the company's point here.
Oh, you do?
Yeah, like if I rob a bank on a Tuesday and then I lie to the police about where I put the money on a Thursday, you don't treat those as two completely unrelated events.
Right.
It's one continuous river of deception stemming from a single crime.
Yeah.
Why is the judge letting Cowger split hairs to save his lawsuit?
It's a very compelling argument, and it is exactly what Signal Peak relied on. But Judge Waters completely rejected that logic, and her reasoning gets to the heart of how employment law separates actions from intent.
Okay, break that down for me.
She made a sharp legal distinction between the events. She wrote that while both events stem from the same original cave-in, allegedly lying to a hospital triage nurse about an ATV accident to save your job is a distinct, separate event from actively misrepresenting vacation time on a federal MSHA form days later.
So they are conceptually different breaches of protocol.
Exactly. And the reason this matters for the good cause standard is profound. Because if the jury believes Cowger was fired for the first lie, the lie coerced by the vice president under threat of termination, a jury might decide that firing a man for yielding to extreme corporate extortion is not good cause.
That makes sense.
However, if the jury believes he was fired for the second lie, falsifying federal documents, they might decide that is good cause, regardless of the coercion.
I see.
Because the reasons are shifting, and the fundamental justice of the firing depends entirely on which reason was the real one, the judge ruled that a jury must be the one to sort out the truth. The bouncer lets him into the club.
This brings up another fascinating debate about how evidence actually works in these types of lawsuits and how massive corporations try to bully cases out of court.
Oh yeah, their legal strategy here was bold.
Signal Peak tried a tactic during summary judgment that honestly sounds incredibly arrogant. They essentially told the judge she shouldn't even listen to Cowger's side of the story because his testimony was just uncorroborated and self-serving.
It's a very aggressive strategy. Signal Peak argued, Your Honor, it is just his word against ours. He has no recordings of these threats. He obviously has a massive financial motive to lie to win this lawsuit, so his testimony is inherently unreliable. Just throw the case out.
Which is a wild thing to say because self-serving is practically the definition of a lawsuit.
Exactly.
You aren't going to spend thousands of dollars to go to federal court to testify against your own interests.
The judge provided a powerful, almost philosophical rebuttal to the company's arrogance. She pointed out the fundamental epistemology of employment disputes. Almost all testimony in these cases is self-serving.
Right.
When you get fired and sue your boss, of course your testimony serves your own narrative.
The judge leaned on a specific precedent for this, right?
Yes. She leaned heavily on Ninth Circuit precedent, specifically a benchmark case called Negro v. Sears, Roebuck & Co.
What does that case say?
The Negro standard establishes a clear rule for judges. A party's sworn testimony, even if it is completely uncorroborated by other witnesses or documents, legally creates a genuine dispute of material fact for a jury, provided it meets 3 strict criteria.
What are criteria?
First, the testimony must be based on personal knowledge. You can't testify about rumors you heard.
Makes sense.
Second, it must be legally relevant to the claim. And third, it must be internally consistent. You can't contradict yourself in your own deposition.
And Cowger's testimony passed the test.
Judge Waters ruled that Cowger's sworn story about what Vice President Musgrave told him met all 3 of these criteria perfectly.
And the judge also pointed out a massive glowing irony in Signal Peak's argument, didn't she?
She did, and it really highlights the hypocrisy of the company's defense. She noted that Signal Peak's entire narrative was also heavily reliant on highly self-serving evidence.
In what way?
To prove their version of events, that Cowger was responsible for the vacation day lie, the company was relying almost exclusively on the internal interviews conducted by Curtis Floyd.
Wait, the same Curtis Floyd who was the safety director?
Yes.
The guy who helped file the false MSHA report in the first place and who was desperately trying to save his own career while the new vice president was auditing the department.
That is the exact man. Floyd had every reason in the world to shift the blame onto Cowger to make himself look clean and competent to the new administration. It is a perfect storm of missing documentation, shifting corporate narratives, and mutual self-preservation. And the judge ruled that sorting out this exact kind of messy, conflicting, highly self-serving testimony is the fundamental constitutional purpose of a jury.
Right. You don't dismiss the case on the sidewalk. You put both men on the witness stand, subject them to cross-examination, and let a jury of citizens weigh their credibility.
Okay, so Cowger wins a major tactical victory here. He survives the motion for summary judgment. He is going to get his day in court in front of a jury to argue the good cause claim.
But before we wrap up our analysis, we have to look at one final ruling the judge made, because she actually handed Signal Peak a massive tactical advantage for that upcoming trial.
She did.
It has to do with how the law views Cowger's specific job title.
Yes, this is a crucial nuance of the WDEA. The court made a definitive, binding ruling on Cowger's employment status. They determined that, as a matter of law, Justin Cowger was a managerial or supervisory employee.
Why does that specific label matter so much in Montana? I thought the WDEA protected everyone who passed probation equally.
It does not. The WDEA is not a monolithic, one-size-fits-all law. The courts recognize that different levels of employees require different levels of corporate control.
Okay.
To determine if someone is a manager, the courts look at factors like whether the employee runs day-to-day operations, the level of independent discretion they exercise, the degree of trust placed in them by ownership, and their direct relationship with upper management.
And how did Cowger fit that profile? I mean, he was physically in the mine, getting crushed by rocks. He wasn't sitting in a boardroom.
True, but the evidence showed he had significant operational authority. Cowger scheduled the crews, he managed employee leave, he oversaw safety compliance on his shifts.
Okay, that sounds like a manager.
Right. He reported directly to the vice president of operations. He was even eligible for a 20% management bonus. In fact, he admitted in his own depositions that he considered himself on the management side.
Okay, so he is officially classified as a manager. Does that mean he gets more protection from the WDEA or less? Because if I am understanding the mechanics of this right, if you work hard, get promoted, and climb the corporate ladder in Montana, your protections against being fired actually get weaker.
That is a very perceptive realization. And structurally, yes, they do.
That's crazy.
Under Montana's Supreme Court precedent interpreting the WDEA, courts afford employers the greatest discretion when they are deciding whether to terminate managerial employees.
Well, why? Shouldn't a manager be harder to fire because they are more valuable to the company?
You have to view it from the perspective of corporate liability and leadership. A company relies intensely on the judgment, integrity, and leadership of its managers to execute its vision, run the business efficiently, and, crucially, to limit legal liability.
Right.
If a manager goes rogue, the company is on the hook. Therefore, the legal standard for what constitutes good cause to fire a manager becomes much broader and more forgiving to the employer.
So how does that broader standard impact Cowger's trial?
If a manager is deeply involved in a lie to federal regulators, even if that manager claims they were explicitly ordered to do it by a superior ridge, a jury will be instructed by the judge that the company has vast, expansive discretion to fire them to protect the integrity of the business.
Wow. So Signal Peak loses the summary judgment motion, but they go into the actual trial knowing the jury will be explicitly told, hey, this guy was a manager, so the company didn't need a perfect reason to fire him. They just needed a plausible business reason.
It is a fascinating, high-stakes legal chess match.
It really is.
The law attempts to balance the individual employee's right to a fair, non-arbitrary hearing with the employer's fundamental right to manage and trust its leadership team.
Let's pull all of these threads together. We started with a terrifying visceral collapse in an underground coal mine, which triggered a panic-induced corporate cover-up driven by the looming threat of FBI scrutiny.
We saw coerced lies told to hospital staff.
Altered federal safety documents.
And a total collapse of executive leadership ending in a cocaine distribution arrest, and a sweeping purge of staff by a new regime.
And through it all, we explored the mechanical intricacies of Montana's Wrongful Discharge from Employment Act.
Which is really the core of this whole thing.
Right. If Justin Cowger lived in any of the other 49 at-will states, he would have been fired, denied compensation, and that would be the end of his story.
The company wouldn't have to explain a single thing to a judge or a jury.
Exactly. But in Montana, because of this unique law, Signal Peak is going to have to stand in a federal courtroom in front of a jury of citizens and prove that their specific reason for firing him was legitimate, factual, and just.
It completely shifts the dynamic of corporate accountability. It forces the company out of the shadows and into the light of the legal system.
It really does.
And it leaves us with a lingering, incredibly complex ethical and legal puzzle to mull over.
Let's say that.
Consider this mechanism. If an employer leverages their immense economic power to extort an employee, forcing them to lie to the federal government in order to protect the company.
Right.
And then months later, that exact same company fires that exact same employee specifically for telling that exact lie in order to look clean for new regulators. How does a jury calculate the moral blame versus the legal right to terminate?
That is the million-dollar question.
If the company holds all the power, can a company functionally manufacture the very good cause it uses to fire you?
That paradox is exactly the kind of question that makes analyzing employment law so compelling. It is ultimately about power, survival, and where the boundaries of coercion are drawn. Thank you so much for joining us as we explore this incredible case. We'll be back next time with more insights to help you navigate the modern workplace. Take care, everyone.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to Carey at capclaw.com. That's capclaw.com.